Hi, I'm Del Copeland and welcome to our Copeland Estates Legal video blog to share information and insights with those families who want to know about their options when they make wills to look after kids under 18 years old. So the first thing that you may want to consider and give some thought to when you have younger kids in particular, so toddler or primary school age, is who will be your executor in your will. So the executor or executors are the people who are going to carry out your wishes. They're going to sign all the paperwork, they're going to make all the decisions, and they'll be in charge of almost everything that you leave behind. Given how important these people or persons are, they obviously must be trusted completely by you to do the right thing and to make the decisions that you would want them to make. If they're good with paperwork as well, then you're onto a winner. Where you have young kids, you would also want to think about the willingness and ability of this person to look after your estate assets until your kids are of age. So the age that they'll inherit is something that you get to decide in your will. If you don't put in a particular age, then the default age will be 18. But it's not uncommon for this age to be increased to 25 or 21 years. Mainly because parents are looking for that added maturity before their kids take over and look after their inheritance themselves to make sure that they don't go out and buy that red hot Ferrari. So this means that if you have a child like me who's 2 and 4, you get hit by a bus tomorrow, then I would want to appoint an executor who would be willing to look after my assets for, in my case, it would be 14 to 16 years before they're 18, and who's young and healthy enough that they're going to be able to look after my kids' inheritance for such an extended period of time. The other part of choosing the right executor, where you do have young kids, is whether it would make sense to appoint the same person that's your executor as your child's guardian under your will. They can be different people. So you have the option. Everything can be customised and drafted to make sure that it looks after what you want it to look after and be what you want it to be. The pros and cons having the same person with the joint roles is that your executor will have control of the assets for the maintenance, education and advancement in life of your kids, and their guardian would have the first-hand knowledge of how to apply the assets for their benefit. It would encourage their interests, their needs, their wants. But the main disadvantage is accountability. When a guardian and an executor are different people, they need to work together, and they can help keep each other accountable that they're both doing the right thing so that they can bounce ideas off one another. They're both involved. One person is not in charge of everything. What a lot of people don't realise is that appointing a guardian for your kids in your will isn't binding. So it's a good idea to have it in there because it confirms your wishes, and those will be considered if there is a dispute, but it isn't going to be something that can be relied on, and if there is a dispute, it will ultimately be something that goes to court if it's not resolved. Where one person survives, that parent would have guardianship under law by default. It's only where both parents are gone that someone else would be appointed. And as with many things in life, communication is key. So it's always best to have conversations with those people about your intentions and with any others that you think might have an issue with it. So I've just touched on it briefly about the age of inheritance. What age should kids get control of their inheritance? So legally, 18 years, that's going to be when your child is an adult under law, but it's only a guidepost. And if you want your kids to inherit when they're a little bit older, it's up to you. And you may want to consider what the appropriate age is, given their likely maturity at that age, and how much you want to reduce the likelihood of them making poor choices instead of investing for their future. So while it's sometimes tempting for some parents to pick an age for their kids that's in their 30s, it has been my experience that that can backfire. And the reasons being that some kids don't really like that when they reach 30 and they want to get hold of the money. It could be that they are just simply mature enough and they could have made use of the funds before then. It sometimes can be quite restrictive. Other times it doesn't matter so much. Only you will know exactly what is better for your family. So most wills prepared by a reputable lawyer will have clauses that allow executors to use and release monies for the purposes of maintenance, advancement in life, education and broadening of the mind until each of your kids come of age. To help your executors, it's a good idea if you can complete an estate planning booklet filled with the details of your finances, tells them where your wills and all your other important documents are kept, family details to assist in completing paperwork. All of those details that your executor are going to need to know at some point, and it'll save them the trouble of trying to hunt the details down themselves. We can provide these booklets to our clients free of charge. Always let your executors know who holds your original will, and this will usually be in the safe custody of the lawyer who prepared it for you. So I'm always happy to answer any questions that anybody may have. You can send me a quick email at hello@copelandlegal.com.au, or you can book in a free 10-minute chat with me through our website, copelandlegal.com.au, and I would be more than willing to help and see if we can put you in the right direction or answer any questions you may have.